Now, in a first for South Africa, Parliament's National Assembly adopted the report of the Committee for the Section 194 Inquiry, which recommended the removal of suspended Public Protector Advocate Busisiwe Mkhwebane from her position. Now, 318 members of Parliament voted for the motion, 43 voted against, with 1 abstention. And this comes after Parliament Section 194 Committee's report found that the suspended Public Protector was guilty of incompetence and misconduct. Mkhwebane's removal comes just before her 7-year non-renewable term expires in October. So, to look at the constitutional and legal implications of this matter, we are joined now virtually by Professor Pierre de Vos, Claude Leon Foundation Chair in Constitutional Governance at the University of Cape Town's Law Faculty. Prof, good morning and welcome to Morning Live.
Good morning and welcome to you and the listeners. Or hello to you and the listeners.
Prof, just how big a moment is this for South Africa, especially looking at the importance this would have for all Chapter 9 institutions?
Yes, well, it is to impeach somebody, whether it's a judge or the public protector that holds an independent constitutional office. It's a huge thing because, of course, in the wrong hands, if it's done badly, it could be abused to affect the integrity and the independence of those institutions. So it's big. But in another way, it's not that big because of the facts, because we know that so many courts, including the Constitutional Court, has made findings about the public protector's incompetence and dishonesty and so on. So it is in some ways even maybe a bit surprising that the Parliament followed through on the facts and did the impeachment without too much politics. Let me not say there was no politics, but following the facts and not ignoring the facts, as parliamentary committees and the National Assembly members sometimes might do.
So we know that the next course of action in this process would be for President Cyril Ramaphosa to assent in order to give effect to this particular motion. But in the lead up to this and just that whole process that was undertaken by the Section 194 Committee, there were, of course, a lot of stop-start moments and quite a bit of pushback from the suspended Public Protector Advocate Busisiwe Mkhwebane, who did cry foul about the fairness of the process. What was your assessment of that process?
Well, the rules of the National Assembly say that the process needs to be reasonable and procedurally fair. In other words, there needs to be a process where all the evidence is presented, where Advocate Mkhwebane could give her version of events and be questioned on it. And so perhaps because of all the stops and starts and because of the threats of legal action challenging various aspects of the procedure, the parliamentary committee actually, in a way, bent over backwards to try and make sure that the process was, in terms of the rules of parliament, fair and reasonable. So I would be very surprised if the arguments that the process was fatally flawed would stand up in court. Maybe there are other arguments that one hasn't thought about yet. But for me, it's striking that this process, given that it's Parliament and those are elected politicians, this process was really trying its best to treat the process seriously and to make a finding based on the facts. Of course, people are going to disagree about certain aspects, but I don't think in essence the wrong decision was taken or that the process didn't give Advocate Mkhwebane all the opportunity to also give her side of the story, which she didn't in the end take up fully.
And to that point, where she didn't take that up fully, her defense has been, and we've spoken to her on this show, we've heard her several times talk about the fact that she did not have a legal representation, which was, of course, also the subject of a previous court ruling. So in that regard, does she have any recourse with regard to where she can go in order to try, at the very least, to hold the rest of this process in abeyance?
Well, there's a possibility, of course, of challenging the committee who made the factual finding on which the final impeachment was based, to challenge that report in court. The legal representation point, I think, is probably not going to fly. The Constitutional Court said that she had a right to be legally represented. That is not a right to be legally represented at the expense of the taxpayers for whatever amount. She did get tens of millions of rands to pay for lawyers, but of course that money was not always wisely spent. So in the end, I would be surprised if a court said that if you're a public office bearer, you have a right to unlimited funds to pay for legal representation if you are then involved in a kind of impeachment process like that. There might be a good argument to be made that the kind of funding that would be available for judges who are going to be impeached, or Chapter 9 body heads to be impeached, that it should be made clear what the parameters of that is, so that there cannot be this kind of exploitation or uncertainty about how much money a person will be able to spend on their legal defense.
But in the absence of those parameters, one can't really charge that, there was an abuse, can you, Prof?
Well, an abuse by, I don't know who you're referring to. I would say that there was clearly the Public Protector's Office had gone out of its way to make money available. When that ran out, they provided another 4 million rand, which most litigants in South Africa, even relatively wealthy ones, would never have to pay for litigation of any kind. So it seems to me the test in the rules that it must be reasonable, what was done must be reasonable, seem to have been met. It would be difficult to see that the court will rule otherwise, especially because the separation of powers. Courts are a little bit circumspect when they look at parliamentary processes. It's very different from reviewing, say, the decision of a magistrate in a criminal case and so forth, because the standards are much higher for what is procedurally fair.
So, Prof, Mkhwebane's term in office will end next month. So what does this process and the vote in Parliament yesterday mean for her benefits?
As I understand it, if you appointed for a fixed term of 7 years as the public protector, you get then at the end, after serving out the term, you get a specific gratuity. It's not a pension, but it's a gratuity basically for services rendered. Impeachment, I think, according to the rules, means then that term is not ended, so it wasn't served out, and so that benefit will not accrue to her. Whether there might still be legal challenges to that, we will have to see. And I haven't really thought about what such a challenge would look like, or whether it would be successful.
And as you say, perhaps not too clear at this stage what that would look like and how it would play out. But if there were to be a legal challenge by Advocate Busisiwe Mkhwebane, what would that mean now for the process? Does it stop here? Is it halted? Or does it still go to the president? What would it mean? And how soon would she have to actually mount that legal challenge?
Yeah, the first thing to note is that the president now has to confirm the decision of the National Assembly. He has no discretion. He doesn't give approval. He must just sign, basically. So it's a formality. If a court case review is launched, that doesn't have to stop. It's not required that stops the process. There can be the process can be concluded. The president can confirm the removal, and then if the court later finds that there was a problem and sets aside the committee report, for example, then that decision, of course, will be invalidated as well. But just reviewing the proceedings at this point is not going to legally stop the president from doing what he's constitutionally required to do, namely to confirm the decision of the National Assembly.
Professor de Vos, now this of course is not just about Advocate Busisiwe Mkhwebane, because one would imagine that this is of course precedent setting, but this will pave the way for future possible removals of Chapter 9 institutions, as you pointed out earlier. But what do you think could have been improved upon in this process? Because I would imagine that, looking back on this, there were some gaps and things that could have been better done, of course.
Yes, I think the biggest, there were two problems with the process, according to me. The one was that it was unnecessarily prolonged, that both the people, the evidence leaders from the National Assembly side and Advocate Mkhwebane and her lawyers they drew out the matter. They provided, in a way, too much evidence, which was not all necessary. There were lots of delays and so on. I think what would really help is for the rules to be added to so that it is made clear, a little bit more clear, what the process will be, what the role of the lawyers will be, and to make sure that everybody's on the same page so that there will not be the possibility of extending the process, of dragging it out, of spending many millions of rands of taxpayers' money that I think need not have been spent to achieve a fair outcome in this case.
And just finally, Prof. de Vos, how much has this tarnished the credibility and the independence of the Public Protector's Office?
That is a very difficult question to say. I think independence also is about institutional independence. I think because this was such a clear case that wasn't really affected here. It's also about perceptions. There has obviously been damage because of perceptions, either from whatever political side you are on, that the Public Protector's Office may have been abused or could be abused. And so the important thing for me is that whenever the National Assembly makes another appointment, as for example, Public Protector, they need to be very careful who they appoint to make sure both that the person is actually competent and impartial and is perceived to be incompetent and impartial, which raises questions about the nominee that Parliament is going to vote for next week or the week after.
Interesting. Thanks so much for your views there, Professor Pierre de Vos, Claude Leon Foundation Chair in Constitutional Governance at the University of Cape Town's Law Faculty, and talking there to us about the constitutional and legal implication after the National Assembly voted to remove Advocate Busisiwe Mkhwebane in her position as the Public Protector.